The large wooden doors of courtroom 7 creaked open, drawing all eyes to the entrance. A hushed silence fell over the packed room as Clint Eastwood walked in with measured steps. At 95, he moved more slowly than in his prime, but still carried himself with the unmistakable dignity that had defined his 6 decades in Hollywood. He wore a simple navy suit, perfectly tailored but deliberately understated. No flashy accessories or power tie, just the quiet confidence of a man who had nothing to prove. The property dispute that brought him here had been brewing for months. Developers had been eyeing land adjacent to his beloved Tehama Golf Club in Carmel, California, claiming rights to water sources that had sustained both the club and surrounding wildlife for decades. When their offers to buy him out were repeatedly declined, they took the matter to court, expecting the aging director to either settle or hire an expensive legal team. They were wrong on both counts. Eastwood nodded politely to a few familiar faces as he made his way through the gallery. A mix of locals, reporters, and curious onlookers filled nearly every seat. Some were supporters who had benefited from his quiet philanthropy in Carmel, where he had once served as mayor. Others were simply there for the spectacle of seeing a Hollywood legend in person. "All rise for the Honorable Judge Catherine Brennan," announced the bailiff, his voice echoing through the high-ceilinged room. Judge Brennan swept in wearing black robes that matched her severe expression. At 52, she had earned a reputation for running an efficient courtroom that didn't cater to egos or celebrities. She had little patience for theatrics and even less for those who thought they could charm their way through legal proceedings. Her dark hair was pulled back in a tight bun, and her sharp eyes surveyed the room with practiced detachment. "Be seated," she said, settling behind the bench and arranging her papers with brisk efficiency. The opposing counsel's table was crowded with 4 attorneys in expensive suits, legal assistants hovering nearby with document boxes. Their lead attorney, Richard Powell, was known for representing large development corporations and had a near-perfect record of victories. Tall and lean with perfectly coiffed silver hair, he exuded the confidence of someone who rarely lost. By contrast, Eastwood sat alone at the defendant's table. No attorneys, no paralegals, just a single leather portfolio and a yellow legal pad in front of him. Judge Brennan glanced up from her papers, her eyes narrowing slightly when she noticed Eastwood's solitary figure. "I see the plaintiff is well represented," she noted. "Mr. Eastwood, where is your counsel today?" Eastwood rose slowly, his voice carrying that familiar gravelly quality that had become his trademark. "Your Honor, I'll be representing myself in this matter." A murmur rippled through the courtroom. Powell exchanged amused glances with his team. Judge Brennan's eyebrows rose. "Mr. Eastwood, while you certainly have the right to represent yourself, I strongly advise against it. This is a complex property dispute involving water rights, environmental regulations, and significant legal precedents." "I understand, Your Honor," Eastwood replied simply. "Do you have any legal training whatsoever?" Her tone made it clear she already knew the answer. "No formal training, Your Honor." The judge leaned forward slightly. "Mr. Eastwood, this isn't a movie set. You can't just walk in and expect to wing it with a few clever lines and a stern look. Real legal proceedings require actual legal expertise." A few nervous chuckles echoed through the gallery. Eastwood remained impassive, his weathered face betraying no emotion. "I understand, Your Honor. I'm prepared to proceed." Judge Brennan sighed, making no attempt to hide her exasperation. "Very well. But don't expect special treatment because of who you are, and I won't be explaining basic legal procedures to accommodate your choice." "Wouldn't dream of it, Your Honor," Eastwood replied. Powell stood, straightening his tie with manicured fingers. "Your Honor, given Mr. Eastwood's lack of legal representation, perhaps we could offer a final opportunity to settle this matter out of court. My clients are prepared to be generous." The condescension in his voice was unmistakable. Several members of the gallery exchanged uncomfortable glances. "Mr. Eastwood?" Judge Brennan asked. Eastwood stood again. "No, thank you, Your Honor. I believe this matter requires a full hearing." The judge shook her head slightly. "Proceed with opening statements, then, Mr. Powell." Powell approached the jury box with practiced ease, his voice taking on the smooth cadence of a seasoned performer. "Ladies and gentlemen of the jury, this case is quite simple despite the defendant's attempts to complicate matters. My clients, Coastal Development Partners, have legal rights to the water sources in question. Rights established through proper channels and documented extensively. He gestured toward Eastwood. While we all respect Mr. Eastwood's contributions to film, respect doesn't extend to ignoring the law. My clients have invested millions in planned sustainable housing that will benefit the entire community. All we're asking is access to water resources that rightfully belong to everyone, not just to the wealthy few who can afford golf club memberships. For the next 30 minutes, Powell laid out his case with polished precision, complete with digital slides showing property lines, water flow diagrams, and projected economic benefits. His team distributed thick binders of supporting documents to the judge and jury. When it was Eastwood's turn, Judge Brennan's impatience was visible. Mr. Eastwood, your opening statement? Please try to keep it relevant to the actual legal matters at hand. Eastwood rose slowly and walked to the center of the courtroom. He carried no notes, no flashy presentations, just the quiet certainty that had become his hallmark through the years. Thank you, Your Honor, he began, his voice low but clear enough to carry to the back row. Folks, I'm not a lawyer. Never claimed to be, but I do know a few things about this land. I've walked every inch of it for the past 40 years. He paused, looking directly at the jury. This isn't about golf, as Mr. Powell suggests. It's about a water system that sustained 5 generations of Carmel families. It's about natural springs that feed into the Carmel River, supporting wildlife that was here long before any of us. One of Powell's junior attorneys leaned over and whispered something that made the lead counsel smile smugly. Judge Brennan tapped her pen impatiently. Mr. Eastwood, emotional appeals about wildlife make for good film, but we need legal arguments in this courtroom. A few people in the gallery chuckled. Eastwood nodded respectfully. You're right, Your Honor, so let me be clear about the legal question. The water rights that Coastal Development is claiming were established through permits issued in 2020, but those permits were granted based on incomplete surveys. Powell's smile faded slightly. The surveys, Eastwood continued, failed to account for the underground tributary system that connects these water sources to protected watersheds under the California Water Protection Act of 1989. Judge Brennan's expression shifted almost imperceptibly. She glanced down at her notes, then back at Eastwood with slightly more attention. Furthermore, Eastwood continued, his pace unhurried, documents filed with the Monterey County Recorder's Office in 1976 established conservation easements that were never properly indexed in the county's digital system after the conversion in. Thou leaned forward, whispering urgently to an associate who began frantically flipping through their documents. Judge Brennan's earlier ridicule had given way to a more measured assessment. These are specific claims, Mr. Eastwood. I assume you have documentation? Yes, Your Honor, Eastwood replied, returning to his table and retrieving several folders from his portfolio. I've brought the original easement documents, along with certified geological surveys from both 1975 and 2018 that clearly show the watershed connections. As the bailiff took the documents to the judge, whispers spread through the courtroom. One older reporter in the back row leaned to his colleague and whispered, "Didn't see that coming." Judge Brennan reviewed the first few pages with increasing interest before looking up. These appear to be in order, though they'll need to be properly entered into evidence. Mr. Powell, were you aware of these easements? Powell stood, his earlier confidence slightly diminished. Your Honor, we've conducted thorough title searches. If such easements exist, they weren't properly recorded or have since expired. We'd need time to review these unexpected documents. You'll have that opportunity during discovery, the judge replied. She turned her attention back to Eastwood. You may continue, Mr. Eastwood. For the next 20 minutes, Eastwood outlined his defense with surprising clarity. No dramatic flair, no actorly delivery, just straightforward facts delivered in his characteristic understated manner. By the time he concluded, the atmosphere in the courtroom had noticeably shifted. Judge Brennan studied him for a moment before speaking. Well, Mr. Eastwood, it seems you've done more homework than I anticipated. We'll see if it's enough. She turned to address the entire court. We'll reconvene tomorrow morning at 9 a.m. for the presentation of evidence. Court is adjourned. As the gavel fell, the gallery erupted in conversation. Powell and his team huddled in urgent discussion, occasionally glancing toward Eastwood, who calmly returned his documents to his portfolio. A young law clerk approached him hesitantly. Mr. Eastwood, that was unexpected. Have you been studying law? Eastwood offered a slight smile, the corners of his eyes crinkling. Just because a man doesn't talk much doesn't mean he isn't listening. He closed his portfolio with a quiet finality. See you tomorrow. As he walked out of the courtroom, more than one person noticed that his slight limp from earlier seemed less pronounced. The day had just begun, and Clint Eastwood had already delivered his first surprise. The morning sun filtered through the tall windows of courtroom 7, casting long rectangles of light across the polished floor. By 8:30 a.m., half an hour before proceedings were set to begin, every seat was filled. Overnight, word had spread about Eastwood's surprising legal knowledge, drawing even more spectators than the previous day. Richard Powell and his team arrived in formation, wheeling in additional document boxes and setting up a small digital projector. They spoke in hushed, urgent tones, occasionally glancing toward the still empty defendant's table. One associate was frantically highlighting passages in a thick legal reference book. At precisely 8:45, Clint Eastwood entered alone through a side door, nodding politely to the bailiff. He carried the same leather portfolio as yesterday, with the addition of a worn copy of California Water Rights, Historical Precedents and Modern Applications. A few people whispered as he walked past, but Eastwood kept his eyes forward, his expression neutral. What none of them knew was that Eastwood had been up since 4:30 a.m., reviewing notes in his study at home. The small room, lined with bookshelves, contained hundreds of law books collected over the past decade. His interest had begun years ago when fighting a different development project, and had slowly grown into something more, a genuine fascination with environmental law and property rights. His longtime housekeeper, Mrs. Chen, had found him at his desk that morning, surrounded by open books and legal pads. "You need breakfast?" Mr. Eastwood, she had insisted, setting down a tray. "Thanks, but I'm running out of time," he'd replied, not looking up from his notes. "They say you were good yesterday," she remarked, pouring his coffee. "On the news." That had made him look up. "News? Local station? Said you surprised everyone." She'd smiled then. "Not me. I've seen the books you read." As the courtroom settled, Judge Brennan entered, her expression marginally less severe than the previous day. "Court is now in session," she announced after the formalities. "We'll continue with Coastal Development's case. Mr. Powell, call your first witness." Powell rose smoothly. "The plaintiff calls Dr. Thomas Reynolds, hydrologist." A trim man in his 50s approached the stand, his confident stride suggesting someone accustomed to being the expert in the room. After being sworn in, he settled into the witness chair with the ease of someone who had testified many times before. "Dr. Reynolds," Powell began after establishing his credentials, "could you explain to the court your findings regarding the water sources in question?" Reynolds nodded, adjusting his glasses. "My team conducted extensive studies of the area over a 6-month period. Our conclusion is that the underground springs on the disputed property are independent from the Carmel River watershed system. They form what we call an isolated aquifer, with no significant impact on surrounding ecosystems." Powell displayed a colorful digital map showing water flows. "And this isolation means?" "It means," Reynolds continued, "that diverting this water for development would have no measurable impact on the golf course or any protected wildlife areas. It's essentially an unused resource." For the next 40 minutes, Reynolds explained water table measurements, flow rates, and geological formations with the polished delivery of a seasoned expert witness. Powell guided him through carefully prepared questions, building what appeared to be an airtight scientific case. When Powell finished, Judge Brennan turned to Eastwood. "Your cross-examination, Mr. Eastwood?" The courtroom tensed with anticipation. Cross-examining an expert witness was challenging even for experienced attorneys. How would a 95-year-old actor with no legal training handle it? Eastwood approached slowly, carrying a single sheet of paper. "Good morning, Dr. Reynolds." "Good morning, Mr. Eastwood," Reynolds replied with a hint of condescension. "That's impressive work you presented," Eastwood began, his tone conversational. "Must have taken a lot of equipment." Reynolds nodded, slightly thrown by the casual approach. "Yes, we used state-of-the-art ground-penetrating radar, seismic imaging, and digital modeling." "Expensive equipment," Eastwood noted. Powell stood. "Objection relevance?" "I'm getting there, Your Honor," Eastwood said calmly. Judge Brennan hesitated. "I'll allow it for now. Keep moving, Mr. Eastwood. Eastwood nodded gratefully. Dr. Reynolds, in your report you mentioned taking core samples at 12 locations. Is that correct? Yes, that's standard procedure. And these samples showed no connection between the aquifer and the larger watershed? Correct. The geological layers clearly show separation. Eastwood paused, studying his paper. I'm curious about something. Your equipment detected no connection to the limestone cavern system that runs beneath the eastern portion of the property? Reynolds blinked, his confident posture faltering slightly. I don't recall any significant cavern system in that area. That's odd, Eastwood said, his gravelly voice even, because in 1976 the U.S. Geological Survey mapped an extensive underwater cave system that connects directly to the Carmel River. He handed his paper to the bailiff. This is the USGS survey map, along with photos from their expedition. Judge Brennan accepted the document, studying it with open interest. Reynolds leaned forward to look at a copy. I wasn't aware of this survey. It was conducted before digital records, Eastwood explained, back when they still filed paper reports. Easy to miss if you're only checking online databases, Powell whispered urgently to an associate, who quickly left the courtroom. Dr. Reynolds, Eastwood continued, if this cave system exists as mapped here, would that change your conclusion about the aquifer being isolated? Reynolds cleared his throat. Well, theoretically, yes. But this is a very old survey. Geological formations change. They do. Eastwood agreed reasonably, which is why I commissioned an updated survey last year. He reached into his portfolio and withdrew a sealed envelope. With the court's permission, I'd like to introduce this as evidence. Judge Brennan's eyebrows rose. You commissioned your own geological survey, Mr. Eastwood? Yes, Your Honor. After the development was first proposed. Just to be thorough, Powell stood again. Objection. This evidence wasn't disclosed during discovery. Judge Brennan turned to Eastwood, her expression now genuinely curious. Mr. Eastwood, Your Honor, the plaintiff's attorneys never requested geological surveys in their discovery motions. They asked for property records, easements, and water usage data, all of which I provided. Eastwood's tone remained respectful but firm. After checking the discovery records, Judge Brennan nodded. He's right, Mr. Powell, the objection is overruled. The court will accept this survey into evidence. The survey, conducted by a respected environmental engineering firm, confirmed the existence of the cave system and its direct connection to both the disputed aquifer and the Carmel River watershed. As Reynolds reviewed it on the stand, his expert facade crumbled visibly. Dr. Reynolds, Eastwood continued gently, would you agree that removing water from this aquifer would, in fact, affect the river system? Reynolds hesitated, looking toward Powell, who was now reviewing the survey with barely concealed alarm. Dr. Reynolds? Judge Brennan prompted. Based on this information, yes, it would likely have an impact, Reynolds admitted reluctantly. The gallery erupted in whispers. Judge Brennan called for order, tapping her gavel once. When Eastwood had no further questions, Powell attempted to rehabilitate his witness through redirect examination, but the damage was done. By the lunch recess, the atmosphere in the courtroom had shifted dramatically. As people filed out, an older court reporter approached Eastwood. Mr. Eastwood, I've covered hundreds of trials. Never seen anything quite like this. Mind if I ask where you learned to cross-examine like that? Eastwood smiled slightly. I've played a lot of roles in my time. Spent 6 decades watching people. You learn to spot when someone's holding something back. He closed his portfolio. And I watch a lot of courtroom shows on TV. The reporter laughed, not realizing Eastwood was only half joking. In truth, Eastwood had spent countless evenings studying trial transcripts, particularly environmental cases. He'd even hired a retired judge as a consultant last year, practicing cross-examination techniques in his living room while his dog dozed nearby. When court resumed after lunch, Powell called a property assessor who testified about the economic benefits the development would bring to Carmel. Judge Brennan, noticeably more attentive now, watched Eastwood carefully during this testimony. The dismissive attitude of yesterday had been replaced by something closer to cautious respect. During his cross-examination, Eastwood methodically exposed that the economic projections failed to account for potential tourism losses if the river's ecosystem was damaged. The witness admitted that no environmental impact study had been factored into their economic models. As the day's proceedings drew to a close, Judge Brennan addressed both parties. It appears we have more complex issues to consider than initially presented. Mr. Powell, your remaining witnesses will be heard tomorrow. Mr. Eastwood, she paused, looking at him with reassessment in her eyes. I look forward to seeing your case in chief. Outside the courthouse, reporters gathered around Powell, who offered polished but notably less confident statements about the day's proceedings. One outdated survey doesn't change the fundamental merits of our case, he insisted, though the strain in his voice suggested otherwise. Eastwood slipped out a side entrance, avoiding the media entirely. In his car, he reviewed his notes for the next day, underlining key points about water conservation ordinances passed during his time as mayor. This wasn't about winning or losing anymore. It was about something his father had taught him long ago. When you believe in something, you stand your ground, especially when everyone expects you to back down. As the sun set over Carmel Bay, casting golden light across the water, Eastwood made one final call to his key witness for tomorrow. There was still much work to be done, and the real fight was just beginning. Day 3 of the trial dawned with a light fog rolling in from the Pacific, shrouding Carmel in a dreamlike mist. The courthouse steps were crowded despite the early hour. Local residents mingled with tourists and film buffs, all hoping to witness the unexpected legal drama unfolding inside. Several carried handmade signs supporting Eastwood, while news vans lined the street. Inside courtroom 7, the atmosphere had shifted noticeably. Powell and his legal team arrived earlier than before, their previous swagger replaced by grim determination. Junior associates balanced laptops on their knees, frantically researching water rights precedents and environmental regulations. Their confidence, so evident on day 1, had been shaken by Eastwood's surprising legal acumen. Judge Brennan entered precisely on time, her stern expression unchanged, but her eyes more attentive as they swept across the courtroom. Where she had once looked at Eastwood with thinly veiled condescension, she now regarded him with cautious curiosity. Court is in session, she announced after the formalities. Mr. Powell, I believe you have one remaining witness. Powell stood straightening his expensive tie. Yes, Your Honor. The plaintiff calls Mr. Robert Wilson, Chief Development Officer for Coastal Development Partners. Wilson took the stand with the practiced ease of a corporate executive. In his late 50s, with salt and pepper hair and a tailored suit that probably cost more than most people's monthly rent, he exuded authority and success. After establishing Wilson's credentials and experience, Powell guided him through testimony about the planned development. Luxury homes with state-of-the-art water conservation systems, community spaces, and economic benefits for Carmel. Digital renderings displayed on a large screen showed tasteful buildings nestled among preserved trees, with walking paths and natural landscaping. And what steps has Coastal taken to ensure environmental protection? Powell asked. Wilson leaned forward earnestly. Environmental responsibility is one of our core values. We've allocated 20% of our budget to conservation efforts, including drought-resistant landscaping and a water reclamation system. Our designs actually use 30% less water than comparable developments. When Powell finished his direct examination, Judge Brennan turned to Eastwood. Your cross-examination, Mr. Eastwood? The courtroom fell silent as Eastwood rose. Yesterday's performance had created expectations and tension hung in the air. Would today be more of the same? Or had he exhausted his surprising legal knowledge? Eastwood approached the witness stand unhurriedly. At 95, he moved with purpose rather than speed. His face weathered, but his eyes sharp and clear. Good morning, Mr. Wilson, he began, his voice that familiar gravelly rumble that had commanded screens for decades. Good morning, Mr. Eastwood, Wilson replied, unable to completely hide the hint of reverence in his voice. Even opposing witnesses weren't immune to the legend's presence. Those are beautiful pictures you showed us, Eastwood said, gesturing toward the screen where the renderings still glowed. Your architects do nice work, Wilson smiled, relaxing slightly. Thank you. We spared no expense. I'm curious about something, Eastwood continued conversationally. Those water reclamation systems you mentioned, they're based on the Halsey method, correct? Wilson blinked, clearly not expecting such a specific question. I believe so, yes. The same system that failed in the Monterey Heights development 2 years ago during the drought. Powell half rose from his chair. Objection, Your Honor. Relevance? I'm establishing the reliability of the proposed conservation measures, Your Honor, Eastwood explained calmly. Judge Brennan nodded. Overruled. The witness will answer. Wilson shifted uncomfortably. There were some technical issues with that installation, yes. But we've made improvements since then. Eastwood nodded thoughtfully. I'm glad to hear that. Now, Mr. Wilson, in your testimony you mentioned that coastal development has completed similar projects in 4 other California coastal communities. That's correct. Could you tell the court about the Santa Cruz watershed project from 2018? Wilson's expression tightened almost imperceptibly. That was a successful beachfront development with 60 luxury units. And wasn't there a class action lawsuit filed by homeowners there last year over water damage caused by improper watershed management? The gallery erupted in murmurs. Powell stood again. Objection, Your Honor. This is outside the scope of direct examination. Judge Brennan leaned forward. Mr. Eastwood? Your Honor, Mr. Wilson testified about Coastal's environmental responsibility and their success with similar projects. Their track record is directly relevant to this case. Judge Brennan considered for a moment. Overruled. The witness will answer. Wilson cleared his throat. There was a lawsuit, but it was settled out of court. No admission of wrongdoing. For $8 million, Eastwood added quietly. Wilson didn't respond, but the muscle tightening in his jaw spoke volumes. Eastwood returned to his table and retrieved a folder. Mr. Wilson, I'd like to introduce these documents as evidence. They're the environmental impact reports from Coastal's last 3 developments. The bailiff distributed copies to the judge, jury, and opposing counsel. If you'll turn to page 17 of each report, Eastwood continued, you'll notice something interesting. The water usage projections are identical in all 3 reports, despite being in different counties with different water tables and rainfall patterns. Wilson's eyes widened slightly as he flipped to the page. In fact, Eastwood continued, his voice still conversational but carrying clearly throughout the now silent courtroom, entire sections appear to be copied and pasted between reports, right down to the typo in paragraph 3 where conservation is misspelled the same way 3 times. Judge Brennan frowned, examining the documents closely. When she looked up, her expression had hardened. Mr. Wilson, can you explain this? Wilson looked toward Powell, who was frantically whispering with his team. I would need to consult with our environmental department. These technical reports are prepared by specialists. I understand, Eastwood said with surprising gentleness. One last question, Mr. Wilson. Your company's filing with the County Water Authority states that this development would use approximately 30,000 gallons daily. Is that correct? Yes, that's our projection. Eastwood nodded, then walked back to his table and picked up a small worn book. Your Honor, I'd like to enter into evidence the Carmel River Watershed Protection Ordinance, passed in 1986 during my term as mayor. He handed it to the bailiff, who passed it to Judge Brennan. Section 12.4 specifically limits new developments in the watershed area to a maximum of 15,000 gallons daily to prevent depletion during drought years. This ordinance was never repealed or amended. Judge Brennan studied the ordinance with open interest. This appears to be correct, Mr. Eastwood. Wilson looked increasingly uncomfortable as Eastwood continued. Furthermore, Your Honor, I have here the original land survey from 1891, which clearly shows that the disputed property was designated as a watershed protection zone by the original town charter. He produced a large, yellowed map in a protective sleeve. The bailiff carefully delivered it to the judge, who examined it with growing fascination. This is remarkable, Mr. Eastwood. Where did you find this? In the Historical Society archives, Eastwood replied. It was misplaced during the courthouse renovation in the 1960s. Powell stood again, his composure slipping. Your Honor, these are ancient documents with questionable relevance to modern water rights law. On the contrary, Eastwood countered, the California Supreme Court held in Ventura County Water District versus Hillside Properties that historical watershed designations remain binding unless explicitly overturned. The Mendoza ruling of 1976 further reinforced that precedent. A hushed silence fell over the courtroom. Even Judge Brennan seemed momentarily at a loss for words. This was no fumbling amateur at work, but someone who had clearly spent considerable time studying the specific legal issues at hand. When she finally spoke, her tone had changed entirely. Mr. Powell, Did your legal team investigate these historical designations in preparing your case? Powell's face flushed. We focused on current water rights law, Your Honor. I see. Two simple words, but delivered with a weight that made Powell shift uncomfortably. By the time court adjourned for lunch, the mood had transformed completely. Reporters scribbled frantically in notebooks while Powell huddled with his team in urgent conversation. Several jury members were openly staring at Eastwood with undisguised admiration. In the hallway outside, an elderly local woman approached Eastwood as he walked slowly toward the exit. I remember when you were mayor, she said, touching his arm gently. You always did your homework back then, too. Eastwood smiled, a genuine smile that softened his weathered features. Some habits you don't outgrow, I guess. As people gathered around him, a young law student pushed forward. Mr. Eastwood, are you sure you never went to law school? Eastwood's eyes crinkled at the corners. Never had the time. But I've always believed that if something's worth fighting for, it's worth understanding completely. He glanced back toward the courtroom, even if no one expects you to. Judge Brennan, watching from the doorway of her chambers, found herself reassessing everything she'd assumed about the aging Hollywood icon. Tomorrow Eastwood would present his full defense, and for the first time in her 15 years on the bench, she found herself genuinely curious about what would come next. The fourth day of trial brought sunshine that flooded courtroom 7 with golden light. The public gallery was packed beyond capacity, with people standing along the back wall. Court officers had to turn away dozens more who lined up outside. Word had spread about Eastwood's surprising performance, drawing legal students, curious locals, and even a few celebrities trying to blend in with the crowd. Powell and his team arrived looking noticeably tired. Dark circles shadowed the lead attorney's eyes, suggesting a long night of emergency preparation. Their document boxes had multiplied overnight, and a new face had joined them. An older attorney with silver hair and wire-rimmed glasses who carried a well-worn copy of California Environmental Law, A Historical Perspective. Judge Brennan entered and surveyed the crowded room with a slight raise of her eyebrows before calling the court to session. Good morning. Today we'll hear the defense's case. Mr. Eastwood, are you prepared to call your first witness? Eastwood stood, looking remarkably fresh despite his 95 years. Yes, Your Honor. The defense calls Dr. Elaine Chen. A woman in her 60s approached the stand with quiet dignity. Her practical pantsuit and sensible shoes contrasted with the corporate polish of yesterday's witnesses. But her credentials were impeccable. 30 years as an environmental scientist specializing in coastal watershed systems, with a focus on California's unique ecosystems. After she was sworn in, Eastwood began his questioning with the ease of someone who had done this many times before, though of course he hadn't. Dr. Chen, could you tell the court about your study of the Carmel River watershed? Certainly. I've been monitoring the Carmel River system for nearly 20 years. It's one of the most delicate and interconnected water systems on the California coast, with underground tributaries that extend far beyond what appears on standard maps. Over the next 30 minutes, Dr. Chen explained in clear, accessible terms how the disputed property served as a critical filtration zone for water entering the main river. Using simple diagrams rather than flashy digital renderings, she illustrated how the proposed development would disrupt water flow patterns that had existed for centuries. Powell watched with mounting concern, occasionally whispering to the new attorney beside him. When Eastwood concluded his direct examination, Powell approached for cross-examination with forced confidence. Dr. Chen, isn't it true that you've been an outspoken critic of coastal development for many years? I've been a critic of irresponsible development, she corrected calmly. I've actually consulted on several successful projects that balanced growth with environmental protection. Powell tried several angles of attack, questioning her methodology, funding sources, and potential bias. But Dr. Chen remained unflappable, her answers measured and backed by decades of research. By the time he returned to his seat, Powell's frustration was visible. After a short recess, Eastwood called his second and final witness, a surprise to those expecting a parade of experts. The defense calls Mr. Frank Takahashi. An elderly Japanese-American man walked slowly to the stand, his back straight despite his evident age. After being sworn in, He settled into the witness chair with the slight discomfort of someone unaccustomed to being the center of attention. Mr. Takahashi, how long has your family lived in Carmel? Eastwood asked. Since 1908, he replied in a quiet voice. My grandfather came to work on the railroad, then started a small farm. I was born here in 1928. And your family's farm is located where? Just downstream from the property we're talking about today. Been there for 3 generations. With gentle questioning, Eastwood drew out how the Takahashi farm had relied on the clean water flowing from the disputed area for over a century. During droughts, when other water sources dried up, the underground springs from that property had kept their crops alive. The developers say their water usage won't affect surrounding properties, Eastwood noted. Based on your experience, do you believe that's true? With respect, no, Takahashi answered simply. During the drought of 1977, the only reason our farm survived was because of those springs. Properties further from that water source lost everything. The personal testimony provided a human dimension to the scientific data. These weren't just abstract, environmental concerns, but real impacts on real people's lives. Several jury members nodded with evident sympathy. Powell's cross-examination was brief and almost perfunctory. There was little he could do to discredit the straightforward testimony of a lifelong resident whose family history was intertwined with the land. After Takahashi stepped down, Judge Brennan turned to Eastwood. Do you have any further witnesses, Mr. Eastwood? No, Your Honor, but I would like to present an alternative proposal for the court's consideration. This was unexpected. Even Judge Brennan looked surprised. Proceed. Eastwood handed document folders to the bailiff, who distributed them to the judge, jury, and opposing counsel. As people began to examine the contents, murmurs spread through the gallery. What I'm proposing, Eastwood explained, standing in the center of the courtroom, is a conservation easement that would protect the critical watershed areas while still allowing limited development on the eastern portion of the property. He walked to a large map display, set up beside the jury box. Using a wooden pointer, he indicated the areas in question. The western 60 acres, where the primary springs are located, would be designated as protected land, no development permitted. The eastern 40 acres, which are outside the critical watershed zone, could support a smaller-scale project. Powell studied the proposal with evident confusion, whispering urgently with the silver-haired attorney beside him. This alternative would protect the water sources that farmers like the Takahashi family depend on, Eastwood continued, his deep voice carrying throughout the silent courtroom. It would preserve wildlife corridors and maintain the natural filtration system that keeps the Carmel River healthy. He pointed to another section of the map. It would also allow coastal development to build approximately 40% of their planned units. Not everything they wanted, but enough for a profitable project that could still benefit the community economically. Judge Brennan leaned forward, openly interested. And you've worked out the legal framework for this compromise? Yes, Your Honor. Eastwood returned to his table and picked up a bound document. This draft conservation easement is modeled after the one that protected the Point Lobos extension in 1996. It includes water rights provisions, building restrictions, and ongoing monitoring requirements. The thoroughness of the proposal silenced the courtroom. This wasn't just a legal defense. It was a fully developed alternative that addressed both environmental concerns and development interests. Powell finally stood, looking somewhat bewildered. Your Honor, while we appreciate Mr. Eastwood's creativity, my clients have already invested millions in the current development plan. We're not here to negotiate a scaled-down version. Judge Brennan's expression cooled. Mr. Powell, the court isn't asking you to accept this proposal at this moment. It's been presented as an alternative for consideration. With all due respect, Your Honor, there's no legal basis for forcing my clients to accept a compromise that significantly reduces their planned development. Eastwood remained calm. Actually, there is. He retrieved another book from his table. California Supreme Court, Monterey Heritage Foundation versus Willow Creek Developers, 1976. The silver-haired attorney at Powell's table suddenly straightened, his expression changing to one of recognition. In that case, Eastwood continued, the court held that when a development threatens an established watershed with historical significance, the court may impose reasonable modifications to protect public water resources under the public trust doctrine. Powell looked to his new colleague, who reluctantly nodded confirmation. The Monterey case isn't widely cited because it had unique circumstances, Eastwood acknowledged. But those circumstances, a coastal property with historical water usage, patterns and downstream dependence, precisely match our situation today, Judge. Brennan accepted the case law volume from the bailiff, finding the marked page and reading silently for a moment. Her eyebrows rose slightly. "He's right," she said finally, almost to herself. Then looking up at Powell, "The precedent does appear applicable." The gallery erupted in whispers. Powell's face flushed as he conferred frantically with his team. Eastwood's voice cut through the growing noise, his characteristic gravelly tone somehow both firm and humble. "Your Honor, the law doesn't care about fame or fortune. It cares about facts. And the facts here support protecting a water system that served this community for generations." For a moment, the only sound was the gentle tick of the courtroom clock. Judge Brennan studied Eastwood with unconcealed reassessment, no longer seeing an actor out of his depth but a prepared advocate with a thorough understanding of the law. "We'll recess until tomorrow morning," she announced finally. "I expect both parties to be prepared to make closing arguments at that time." As the gallery buzzed with excited conversation, Powell gathered his documents with sharp, angry movements. His clients, executives from coastal development who had attended for the first time today, surrounded him with worried expressions and urgent questions. Eastwood packed his materials methodically, seemingly oblivious to the admiring glances from spectators. A young law clerk approached him hesitantly. "Mr. Eastwood, that was incredible. The Monterey case is so obscure. Most practicing attorneys don't even know about it." Eastwood looked up with a slight smile. "It's amazing what you can learn when no one expects you to be listening." Outside the courthouse, reporters mobbed him with questions about his surprising legal knowledge. With characteristic understatement, he deflected most queries. "I just did my homework," he told them before slipping into his waiting car. Nothing special about that. But as he drove home along the coastal highway, windows down to let in the ocean breeze, Eastwood allowed himself a small smile. Tomorrow would bring closing arguments and eventually a verdict, but today had changed something fundamental. Win or lose, he had shown that assumptions about age and background meant nothing when matched against preparation and conviction. He had one more card to play tomorrow, one final piece of evidence he'd saved for the right moment. Whether it would be enough remained to be seen. The fifth day of trial brought clear skies and an air of anticipation that spread throughout Carmel. The courthouse steps were so crowded that deputies had to form a pathway for those entering the building. News vans lined the street, their satellite dishes pointed skyward. Inside, every seat was filled half an hour before proceedings were scheduled to begin. Judge Brennan entered the courtroom at precisely 9 a.m., her robes perfectly pressed and her expression thoughtful. The gallery rose and then settled into an expectant hush as she called the court to order. "We'll begin with closing arguments," she announced. "Mr. Powell, you may proceed." Powell approached the jury box with the polished confidence that had marked his career. Whatever doubts the past days had created, he had rallied overnight. His silver-haired colleague had clearly helped him prepare, as his argument now incorporated sophisticated responses to Eastwood's legal points. "Ladies and gentlemen of the jury," Powell began, "this case may have taken some unexpected turns, but the fundamental legal principles remain clear. Coastal development has followed all current regulations in their plans. They've obtained the necessary permits through proper channels." He acknowledged the historical evidence Eastwood had presented, but argued that modern development law superseded century-old designations. He emphasized the economic benefits the luxury homes would bring to Carmel, and suggested that Eastwood's concerns, while perhaps well-intentioned, were exaggerated. "Mr. Eastwood has impressed us all with his unexpected legal knowledge," Powell conceded with a slight smile. "But impressive performances shouldn't distract us from the facts. And the fact is, my clients have legal rights to develop this property as planned." He concluded by urging the jury to focus on current law, rather than emotional appeals about the environment or history. It was a strong recovery from yesterday's setbacks, reasonable, measured, and grounded in modern legal precedent. As Powell returned to his seat, Judge Brennan turned to Eastwood. "Mr. Eastwood, your closing argument." Eastwood rose slowly, his movements deliberate but not frail. As he walked to the center of the courtroom, A shaft of sunlight from the high windows illuminated him briefly, highlighting the weathered contours of his face. At 95, he carried the dignity of a man who had lived through nearly a century of American history. He didn't approach the jury box immediately. Instead, he stood in the open space before the judge's bench, his hands relaxed at his sides. "Your Honor, members of the jury," he began, his gravelly voice soft but carrying to every corner of the silent room. "This case isn't just about property rights or water sources or development permits. It's about stewardship." He paused, looking at each jury member in turn. "My father was born in 1896. He used to tell me about a California that existed before highways and subdivisions, when the coast was wild and the water ran clean. He wasn't against progress, he embraced it. But he believed that each generation had a responsibility to protect something of what came before." Eastwood walked slowly toward the jury. "When I moved to Carmel, permanently in 1972, I made a promise to myself that I would be a good steward of whatever small piece of it came under my care. That's all I'm trying to do today." He turned and gestured toward the executives from Coastal Development. "I don't question their right to build. I question whether their right extends to damaging water sources that have sustained this community for generations." Eastwood returned to his table and picked up a single sheet of paper. "I have one final piece of evidence I'd like to present." With the court's permission, Judge Brennan nodded. "Go ahead, Mr. Eastwood. This is a letter written in 1976 by the then chairman of the California Coastal Commission, explaining the decision to designate the disputed property as a watershed protection zone." The bailiff delivered the letter to Judge Brennan, who read it with visible interest before passing it to the jury. The letter specifically notes that this designation was meant to be permanent, regardless of future development pressures, due to the unique geological features of the aquifer system. Powell rose halfway. "Your Honor, this letter wasn't disclosed during discovery." "Because I only found it yesterday," Eastwood explained. "It was misfiled in the Coastal Commission archives under Monterey County Tourism. My researcher located it late last night." Judge Brennan considered this. "I'll allow it as newly discovered evidence." As the jury examined the letter, Eastwood continued, "The law does indeed care about facts, as I said yesterday, and the facts here are clear. This water system is irreplaceable. Once damaged, it cannot be restored. The development as currently planned would cause that damage, despite assurances to the contrary." He gestured to the compromise proposal he had presented the previous day. "The alternative I've suggested balances protection with progress. It allows development where it can be done safely, while preserving the critical watershed areas that so many depend on." Eastwood's voice remained even, never rising for dramatic effect. He didn't need theatrics. The simple, unvarnished truth of his words carried their own weight. The people of Carmel, not just today but generations to come, deserve clean water and healthy ecosystems. They also deserve thoughtful development that respects both history and future needs. We can have both, but only if we recognize that some things once lost can never be replaced. He returned to his seat without another word, leaving a profound silence in his wake. Even Powell seemed momentarily affected by the simple eloquence of his argument. After a short recess, the jury retired to deliberate. Most observers expected lengthy discussions, but they returned after just 90 minutes, a sign that Eastwood's arguments had been persuasive. As the courtroom settled, the jury forewoman stood. "Has the jury reached a verdict?" Judge Brennan asked. "We have, Your Honor." The verdict was clear. While Coastal Development had the right to build on the property, their current plans were deemed harmful to the public interest due to potential damage to the watershed. The jury recommended adoption of Eastwood's compromise proposal, with minor modifications to increase the buildable area slightly, while still protecting the core water resources. Judge Brennan accepted the verdict with a nod. "I find the jury's decision to be reasonable and supported by the evidence presented. Mr. Powell, please inform your clients that they may proceed with development only under the modified plan as outlined by the jury." Powell's clients looked displeased but resigned. They had expected a complete victory and instead faced significant restrictions on their plans. As the court prepared to adjourn, Judge Brennan did something unusual. She addressed Eastwood directly. "Mr. Eastwood, I owe you an apology. On the first day of this trial, I made assumptions about your capabilities based on your background and age. I was wrong to do so. The courtroom fell silent, surprised by this rare admission from a judge known for her stern demeanor. You have demonstrated exceptional legal acumen and a deep respect for the law that many trained attorneys would do well to emulate. This court thanks you for your thorough preparation and thoughtful advocacy. Eastwood nodded once in acknowledgement, his expression revealing little of what he might be feeling. Outside the courthouse, reporters swarmed around both parties. Powell gave clipped responses, professionally accepting the verdict while hinting at a possible appeal. His client slipped away to waiting cars, clearly eager to avoid further questions. When Eastwood emerged, a cheer went up from the gathered crowd. He paused at the top of the steps, looking somewhat surprised by the response. A forest of microphones thrust toward him as reporters shouted questions. How does it feel to win against a team of professional lawyers? Did you secretly go to law school? Will you be representing yourself in future cases? Eastwood raised a hand, and the crowd quieted immediately. The same commanding presence that had controlled movie sets for decades now focused on the courthouse steps. I just did my homework, he said simply. Nothing extraordinary about that. A young reporter persisted. But you beat a whole team of corporate lawyers. Eastwood's eyes crinkled slightly at the corners. Not quite a smile, but close. The law doesn't care who you are or what you've done before. It only cares about the facts and how well you understand them. As he made his way down the steps, people reached out to pat his shoulder or shake his hand. An elderly woman pressed close to whisper, "You showed them, Clint." Later that evening, as sunset painted the Carmel coastline in shades of gold and pink, Eastwood stood at his living room window, watching the ocean. The phone had been ringing all afternoon with congratulations and interview requests, but he'd let them all go to voicemail. This victory wasn't about publicity. On his desk lay a handwritten note from Judge Brennan that had been delivered by courier. You reminded me today of something I'd forgotten. Never judge a book by its cover, especially when that cover has years of wisdom behind it. Thank you for the lesson in humility. Eastwood folded the note and slipped it into his pocket. Tomorrow there would be paperwork to finalize and conservation experts to consult. The real work of protecting the watershed was just beginning. But for tonight, there was satisfaction in knowing that sometimes, against all expectations, doing your homework was enough to make a difference.